So we welcome you to today's webinar, and we hope we can add some value to your business. So we're going to jump into the panel discussion, and I'm going to turn it over now to Charles Jimerson.
Thank you, Nikos. Excellent job as always. Good morning to everyone out there. I'll spare us a lot of fluff and really just get into the discussion. Just by way of a roadmap, the things that we're going to cover today are going to be fairly broad, but we'll drill down on the nuanced points that hopefully are best practices or practical pointers that you can take with you in your day in, day out operations of a special asset department or the administration of a problem loan. First, we'll just do kind of a quick update refresher on COVID related regulations, where we're at, how that's impairing, if at all, evictions, foreclosures, to the extent that that's going to work its way through from a regulatory standpoint. We'll touch on that and give you some takeaways as to what you need to know when things are fully opened up so that you can foreclose. We'll then move on to a topic that's what's new since the foreclosure crisis. And there's been a lot of developments in the law and in our court system since that 2007 to 2010 timeframe, which I think that any diligent officer would need to be apprised of. We'll then touch on best practices in avoiding pitfalls. There's a lot that our panelists have learned through trial and error, through experiences, and some things that they can give you that will help you avoid making mistakes that are common in the banking industry. And lastly, we'll close with a topic of you foreclosed on the property, now what? And we'll be able to speak to some disposition and deficiency related issues that we've encountered in practice. So with my first question, I'm going to start it out to Austin Calhoun. And Austin, just the table set on where we're at right now in the industry, what restrictions may be applicable to collecting on defaulted consumer or commercial loans as a result of COVID-19 related federal, state, or local regulations?
Thank you, Charlie. Well, we may all be aware that there has been a moratorium on foreclosures and evictions that was quickly implemented at the beginning of last year when COVID-19 began. Where are we now? Well, it's less impactful now than it was 6 months ago. Currently, only federally backed loans are subject to a moratorium. Just last month, President Biden extended the forbearance and foreclosure moratorium for homeowners of federally backed loans. It was set to expire on March 1st. It's now been extended to June 30th of this year. And again, that would affect any FHA, VA, Fannie Mae, Freddie Mac loans. On a Florida level, Governor DeSantis did enact a moratorium last year, but that expired in October of last year. And so currently, and since October, we've been pushing cases all the way through to foreclosure and eviction of homeowners where they're not federally backed loans. There are a few counties that have enacted their own regulations, but those have, for the most part, are limited to renters and not foreclosures. And on the commercial side, there's been no real impact.
Austin, any insight on how long these restrictions last, whether they may be extended, and then what kind of impact would you expect on the court system once those restrictions are lifted?
For Florida, those restrictions are done on a state basis. They're no longer in place, and I don't see them coming back. On the federally backed loan side, I would not be surprised if we see another extension. How far into the future, hard to say, but wouldn't be shocked if we saw them extended through the end of this year. As far as the impact on the courts once those are lifted, there'll be some level of impact, but maybe not as much as you may think. The court systems have been handling those cases for the most part have been filed. They're just sitting in a holding pattern until those federally backed moratoriums are lifted. But they seem to be getting teed up for a quicker resolution once the restrictions are lifted.
Do you get the feeling that a large volume of foreclosures, if that is what happened, can be supported by our current court system?
More so now than a decade ago. I think Brandon may talk a little bit more detail about that later. But the short answer to that is yes, I do.
So just kind of to put a bow on that, Austin, so if you had to identify the main 2 or 3 boxes that needed to be checked by a SAD officer advancing on a defaulted credit in this COVID area, which is, uncharted territory for us all, what would those boxes be?
Well, nothing exotic. It's really sticking with the basics, except for the Reg X servicing rules that most of you watching this should be aware of. So that's a box that you need to check for sure. Make sure you're developing processes to stay in compliance. You want your processes and compliance to be tight in the event that there is a flood of new foreclosures that come in volume of files that ramps up. You wouldn't want to get bogged down in trying to navigate the Reg X rules. You need to know them well and have streamlined processes in place. Just another one would be brush up on best practices. Make sure your tools are sharp in the event that volume of files increases. You want to be efficient and effective. And that's just things like making sure you have the original note in your possession, tracing the loan modification history to identify any hiccups in the papering up, documenting of the loan. Is the legal description proper? Are you going to need to fix that? Do you have a recent appraisal of the collateral? Have you inspected the collateral recently? Are the taxes and insurance paid? So those are just a highlight of some of the best practices just to make part of your routine and check those boxes on all your files. And lastly, just make sure you're moving your files as quickly as you can now. You don't want to have a big backlog of stale files in the event volume of files increases.
Thank you, Austin. We're going to pivot to our next topic, which is understanding. Next topic is going to be understanding what's new in the foreclosure world since our last adventure in 2007 through 10 to 13 timeframe. We'll focus on what's new in the law and what's new in the court system. So I'm going to now direct this question to Brandon Meadows. Now, Brandon, from 2007 to 2010, the U.S. housing market experienced a great volume of property seizures, which became known in the media as the Foreclosure Crisis, and that substantially contributed to what's been deemed the Great Recession. The post-mortem on that was the extension of shaky credits secured by far-fetched mortgage collateral, sometimes complicated schemes of mortgage debt securitization, and then a rapid increase of volume of foreclosures is what contributed to what was called a crisis. So first, let me direct the question to you as it pertains to foreclosures in Florida. How has the law changed, and how has our court system changed since experiencing that avalanche of cases that worked its way through the pipeline in the 2007 to 2010 to 2013 timeframe?
Thank you, Charlie. Yeah, so a lot's changed, both procedurally and substantively with the law. I think just to start procedurally, the good news is a lot of county courts across the state had developed dedicated and separate foreclosure divisions. And so there was a recognition of this volume of work that sort of need to be parsed out and separated on its own sort of conveyor belt, if you will, of substantially similar cases that were handled by the same judges. And so what we saw in response to that, volume of work, particularly in the Fourth Circuit, in Duval County and Clay and Nassau, is what we saw was a lot of senior judges were being assigned and circuit judges were being assigned to this separate foreclosure division. And the great part about that was it created this consistent, you knew what to expect with a set of case management conferences where, every 30 to 45 days you were back before the judge on scheduled, we call them CMCs, case management conferences. And that was great for lenders because we all know when you're dealing with foreclosure defense, a lot of that is they just want to stay in the property as long as possible. They want to kick the can. A lot of the defenses are do not have merit. Very few of them do, and it's particularly in residential type cases. And so the great thing about that was the case management conferences within the foreclosure divisions created accountability, where it kept those cases consistently moving. It kept the pressure on, and we really took advantage of that because we could get our motions teed up and have them heard at these regularly scheduled conferences. So that was sort of procedurally a great thing that Florida did to kind of deal with that volume. And so all of that is set in place, and we're ready, as Austin mentioned earlier, sort of to handle that flow. Should it be a situation where there's a high volume akin to what we saw a decade ago. And then substantively, there have been.
Let me chime in on that one, Brandon, if I may.
Sure.
Are the courts ready to flip the switch and maintain those regenicize those foreclosure divisions and make sure we're in a position that they could ramp up to handle that volume right away, in your assessment?
Yeah, so I think they can. I'm reading and I'm hearing a lot of conflicting things about what's going to actually happen. So I'm not here. If I had the crystal ball, perhaps I wouldn't be here today if I could predict the future. But I think the answer in short is yes. The courts administratively have been doing what they needed to do and have the infrastructure in place to handle the cases. Now, what that's going to look like, we just don't know. As Austin mentioned, there is a logjam of foreclosures that are basically have been sitting there. And then on the federally backed side, yes, I mean, we're looking at summer and we don't even know if that's actually going to be the hard deadline. But, remember before, there were already many foreclosures that were making their way through the system before the moratorium started. And, a lot of them are just waiting in the wings to be cleared. And, if the economy doesn't recover quicker, I mean, we will see, a wave and we'll see more volume. But I think in short, yeah, I think the courts are well equipped to handle a volume, or at least they have a solution, right? They have a process that I think is tried and true.
Right. And sorry, back to what you were explaining, perhaps some other additional changes that might be new.
Right. So that's sort of procedural, but there have been some changes to the rules of civil procedure and changes to Florida statutes, and then really some more consistency that's developed in the law in the last 10 years that we perceive to really be lender favorable. And so that's been great. But, just a couple things, so what we saw coming out of 2007 was there were a lot of paper being sold on the derivative market. There were a lot of changes with exchanges of note sales, and we saw the robo signing issue. And so there was this massive problem with standing and, making sure that the lenders own and held the note. And so there's been a lot of case law that's developed there that I think has been sort of lender friendly. But then from procedurally, what's been required is we now have to file verified complaints that certify that we have possession of the note. So that certificate of possession of the original note is a good thing in that it required the lenders to establish just a very baseline that they have standing, that they have the note or they're entitled to enforce the note. And that's good from a legal perspective because those are documents we need anyway. There was before 2007, before, in the years that followed it, we wouldn't be talking about the original note and having possession of it to hand to the court at final judgment until sometime later. So it was great to sort of have that, to have to do that up front, and it really made sense. And so I'm sure that you all are aware of that. And then furthermore, there's been a new summary judgment standard that's been promulgated by the Florida Supreme Court that actually starts in May 1 of this year, and that's going to be great, I think, for lenders because it's going to align us with the federal rules, and it's going to really favor the lenders in that it relaxes the standard on summary judgment. Oftentimes, that's where a lot of the foreclosures cases have finality. We don't really try not to take a lot of these to trial. And so there's going to be a relaxation of that standard to be in line with the federal rules, which we think will favor lenders. That starts in May. Other things that have changed is we've seen just recently in the last year, there's been changes to a Uniform Receivership Act. And that was so that was last July. And, we can maybe talk about that a little bit later, but, when I deal with a lot of commercial foreclosures, appointment of receivers are often a consideration. And so there's been a lot of the common law has been codified into a uniform statute in Chapter 714, and it's really defined the parameters of what lenders can do to get in there. For instance, in a hotel scenario where you're concerned about waste, you have other UCC1 liens on furniture, fixtures, accounts receivable, and you really want to make sure that if you're in an undersecured position, or if you're concerned about waste or to the collateral, you can really get in there and you have a really good defined set of rules. So that's been kind of new, and we'll see how the case law kind of treats that. But again, that's just another tool that's in our toolbox. And then I would say, lastly, not really new, but something that I always employ as a legal strategy is that fast track foreclosure process. Whether it's residential or on the commercial side, there are things you can do immediately on the heels of filing the complaint in the order to show cause process, where you can require the borrower to show up and explain to the court within 20, 30 days why foreclosure shouldn't be entered right now. And then on the commercial side, you can get them to make payments during the pendency of the foreclosure action. Those are really great lever points that we always access really early on in the case, because the last thing you want to do is have a borrower fund its defense war chest with the money that you loaned them. And so anything you can do to sort of take those arrows out of their quiver is an advantage to the lender. So I would just say holistically, there's been a lot of changes, mostly in the law, that's been really favorable, I think, for the lenders. And I think it's created some consistency, and it's also created some a comfort in knowing what to expect.
Couple of follow-ups on that. On that note, with regard to those fast track procedures, 70210, is that something that you see is being utilized frequently since its implementation? And can you think of what percentage of the time should those type of fast track procedures be invoked?
We do them. That's for us at our firm. That's something that I always counsel clients on is, hey, we have this fast acting remedy. We've had the fortune of stepping in and taking over cases that were perhaps gummed up or got a little more complicated along the way. And I've seen cases many times where these fast track procedures weren't really employed. That's a real, somewhat of a head scratcher to me, because why not make defendants pay to play? Why not make them make regular payments and give you a shorter leash within which, just another obligation that they have to comply with, or they'll be foreclosed on. As it relates to, when we do it, I don't see a situation why you wouldn't do that, why you wouldn't require, whether it's residential side or the commercial side. There are a little bit of nuances in the differences of what your remedies are, but I don't see a situation where you wouldn't do it. And frankly, I am surprised when I'm counseling clients on, hey, did you know about this? This is a law that's been in place for 20 years. So I'm surprised that, the really, when I don't see it happening, I wonder why we're not using that. I mean, we need to come in, we need to apply pressure, and we need to move as fast as we can to get the collateral back.
You'd mentioned briefly technology. Is the lending industry better off or worse off for trial by Zoom or hearing by Zoom that the courts system have accommodated the legal proceeding with during the COVID era?
I think that technology has really changed how we're practicing law. Technology is changing how in-house counsel and how SAD officers are managing litigation. It's a game changer. There's no doubt about it. And the legal industry isn't the only one that's being affected. I'm sure you all know. But for Zoom, look, over the past year, I've had several evidentiary hearings that have gone on without a hitch. I've had several depositions of witnesses that have gone on without a hitch, several hearings. And I'll tell you what you're seeing is a lot of cost savings in litigation, because instead of packing up the briefcase and, maybe staying in a hotel or even just traveling, out my window here is the Duval County Courthouse. And so even traveling, to the courthouse, unpacking the bag, sitting there and waiting for the judge to show up, there's a lot of lost time there that usually gets passed through to the clients. And now, a 1 hour or a 2 hour, run-of-the-mill motion practice in a foreclosure now becomes, a 15 to 30-minute endeavor. And so that's great. And it's from my perspective as a practitioner, I haven't really noticed, and we can get into all the nuances of that, but I really haven't noticed a really big negative drawback to having those. And then furthermore, it really allows us to be here in Jacksonville, but handle cases all over the state. And so we're sort of can be, everywhere now because of it. And in the legal industry, judges and practitioners, there's a lot of old guard, and we noticed that it's uncommon to embrace technology, but this really forced us, what we dealt with in the last year really forced us to embrace it. And I believe it's changed the game for good. And I think it's here to stay.
Yeah, that last point is a critical one for the lenders in terms of the need to have unique relationships in every single market. I think our hub and spoke model that has our headquarters here in Jacksonville, and then 5 different offices across the state with a physical presence, but a centralized hub, has allowed some of our clients to centralize work through us. And with technology, we've been able to cover ground in a more cost-effective manner than perhaps shipping it off to 5 different law firms in 5 different states. So that's definitely a practical point that hopefully will save our clients money in the future. Brandon, one more follow-up with you is for those SAD officers who have, were tough enough to weather the storm through the foreclosure crisis. What's that one big thing that they need to take away from the way things used to be done versus the way that they are done now a decade later?
Oh gosh, I would just say there's probably not one big thing. I think probably if I were to say that, I would harken back to the technology. I think that's huge. That's really changes the cost savings component and how your litigation is managed. But I think we all know that there's been a lot of changes to regulatory and reporting issues. There's going to be probably a lot less legal standing issues. I think that if I were to say, like the one big changes would be just the sophistication and the development of the law in this area, because there were so many issues raised, so many cases tried in the last 10 years. And I guess the big thing is there's a lot more consistency in the law and how it's developed. So that should be great for lenders, because all of the law that I've seen has sort of been tilted, in favor of protecting the lenders and enabling us to move forward swiftly and efficiently through the system.
How about those standing issues that were real cripplers during that time, where the debtors counsel and the bankruptcy bar were real jazzed that they could get free houses back in the day. Are those issues still around, and has the law evolved to account for that so that we're not giving away free houses?
Well, no, I think that judges looked at the equities, and if there was a technical issue, there was always a later loophole that was fixed or plugged. I'm sure we've all read and heard about the nightmare cases. But so what I have seen, however, is the industry responding, right? So being better with the way that we have a chain of custody for the notes and how we endorse them and how we warehouse them, and making sure that, you know, the issues that we had in the past with robo-signing and not having the actual paper, a lot of those things have sort of changed, and those processes have been buttoned up and tightened up. So I think that there has been sort of two pieces to that. The changes in the law, they're not going to allow someone to have a free house, but then also the legal industry, or I'm sorry, the banking industry has paid attention to that and have modified their processes accordingly. So I don't think we're going to see that as much as we've seen before, although it is an issue.
Let's get one of our other panelists in here. I've got a question for Austin Hamilton, and this is a bit of a expectation developer for our attendees. In your experience, Austin Hamilton, how many days should a lender expect for a foreclosure to make its way through the system, either from the time that the demand letter is sent or the time that the foreclosure is in fact filed with the courts?
Sure. Well, thank you, Charlie, and good morning, everyone. I'm glad to be here. So assuming that the matter is uncontested, the best case scenario is generally around 4 months from the date of filing the complaint. Generally, from a rule of thumb standpoint, it's generally 30 days from the date of filing the complaint to obtaining the default, except for when you have service issues, which I'll address in a moment. And then there's usually about 45 days thereafter in order to obtain the final judgment. Generally, the judges will require a hearing. And then also from the date of the final judgment through the date of the foreclosure sale, it's usually between 30 and 45 days out, where the judge will set the foreclosure sale. Now, some of the events that may affect that time frame from an uncontested foreclosure standpoint would include the number of defendants that there are to have served, whether there are any service issues such as having to serve via publication, whether the borrower is alive or dead, etc. Competent counsel, though, can try to push those matters forward and try to stay in front of those matters and hopefully try to cut them off at the infancy.
Austin Hamilton, how much, and we've got a bunch of Austins around here, so you'll hear me saying Austin Hamilton because we've got two on this webinar alone. But how much time is added to a foreclosure case when it becomes contested? You had drawn that line in the sand of contested versus uncontested. Can you elaborate on that?
Sure, Charlie. That's a great question, because there is that line in the sand. When there is a contested foreclosure, there's really no one size fits all answer there. It's going to depend typically on the defenses that were raised and the nature by which the action is contested. Some examples would be if a bankruptcy filing has occurred, if the defendant has raised any legitimate defenses or any factual issues that may result in additional discovery or potentially depositions, whether there are motions for extension of time that are filed, whether there's various or excessive motion practice, etc. Now, my job and our firm's job from a contested foreclosure standpoint is to set those expectations with the client and to push the matter forward. An example of a way to push the matter forward is what Brandon was talking about earlier, using the fast track process and shifting the burden to the defendant to come forth and to show a genuine issue as to why a judgment should not be had. Another way would be to immediately set the case for trial once the case is at issue, meaning once you have your complaint, your answer, and your reply, set the case for trial, and also using the motion for summary judgment process, either a partial summary judgment or full summary judgment. One thing that I have noticed, being on both sides of the foreclosure process, is a lot of times the plaintiff's counsel won't move for summary judgment early. They'll allow the defense to set the tone and allow discovery issues to prevent the summary judgment. Whereas if you move for summary judgment timely, and then the other side, the defendant says we need to conduct some discovery, at least you have your motion filed, and the judge will hopefully set an expectation for how quick discovery needs to be conducted. That way you can bring some finality to the contested foreclosure.
When you're talking about discovery and things that you can do to perhaps streamline that discovery, you're talking about these are real practical day in, day out disruptions to everybody's process at the bank, right? I mean, when discovery means your team's getting deposed, you're getting all sorts of documentary fishing expeditions, just a massive disruption in your workflow. You're saying that there's things that you can do that minimizes that, right?
That's correct.
Yeah. So without dragging us into the weeds, Austin Hamilton, how would a 16, 24 month, week foreclosure turn into a nightmarish multi-year litigation? Maybe what are some ways that you can avoid those things?
Sure. I mean, one example, or a couple examples that I've actually, touched on would be a bankruptcy filing. There's going to be an automatic stay. You have to get it out of the bankruptcy so you can move forward with the foreclosure. Additionally, when you get into standing or factual issues, that goes into the discovery that I was just talking about, and I used the term discovery broadly. But if there's a legitimate issue and the defendant their counsel wants to take a deposition of someone, of course it's going to be an interruption. It's going to take time to coordinate that. They have to set forth, if it's a corporate representative, they have to identify exactly who is going to be that what those areas are. If they want documents, I mean, there's all of those add additional time, and so there's different ways to try to limit those burdens. And really, the big one that I touched on was using the summary judgment process. If you file a motion for summary judgment, typically the other side's still entitled to conduct the discovery to the extent that there's anything that they need to combat that motion. But if you can go in front of the judge and say, look, we filed a motion for summary judgment, I'm fine with giving them, a month, 2 months to conduct their discovery, but I want to have this summary judgment motion heard, 2 months down the road. That will allow the time frame to be curtailed, and it will essentially allow or prevent the defendant from conducting additional discovery, or force them to do that timely to help expedite the foreclosure.
Yeah, it's you hear those horror stories, and it's an extreme rarity when we've been on the other side representing a borrower against the lender, but it has happened in one-off circumstances a long time ago. And there's been circumstances where we are able to, just through crafty litigating, extend a foreclosure 10 years. And some of the things that we were pretty good at in facilitating that, some of those we were just dumb luck, with transitioning of ownership. But there are things, if you do not have an active law firm on the other side who employs technology to stay organized, to handle the volume, and with aggressive litigation, that a foreclosure can really slip through the cracks. Before we move to the next broad topic, we have a question from our audience, and we can start with either Brandon or Austin Calhoun. And the question is as follows. Under the CARES Act, many residential mortgages will go unpaid for, looks like, up to 18 months while they're in forbearance, and servicers are concerned with their collateral deteriorating. Does Florida law require servicers to inspect mortgaged residential properties when the property is 1, delinquent, 2, in forbearance, and/or 3, in foreclosure? And then the follow-up question to that, is there a distinction in the requirements between the 3 stages? So, in other words, legal requirement regarding inspection on Florida law. Gentlemen?
Charlie, I'll take that, and Brandon, you can supplement as needed. And this is Austin Calhoun. Under Florida law, I'm not aware of any requirement to inspect. I think the genesis of the question may be some of the federally backed loans do require inspection of the collateral upon delinquency, just to ensure and preserve the value of the collateral that may be backed by the government. And within the CARES Act, none of those charges can be passed on to the borrower or charged to the loan during the CARES Act forbearance. Whereas, before the forbearance, under a normal circumstance, they would be passed on to the borrower. And so, since they can't be passed on to the borrower under the CARES Act forbearance, the various federal agencies have allowed for the inspections to not be required in most instances during the forbearance, unless it's determined that the property is vacant or abandoned, which is not the typical case when there's a CARES Act forbearance. Normally that's homeowners trying to stay in their homes. But back to, non-federally backed loans under Florida law, not aware of a requirement per se, but you most likely have the right and the opportunity under your loan documents to inspect the collateral, which you should consider, and we suggest, at least on a reasonably periodic basis, when the loan becomes delinquent, just to identify any concerns with preservation of value of your collateral.
Thank you. Anything else from the panel on that question? Great. So let's move on to our next broader topic, which is really best practices in avoiding pitfalls. I'll direct the question to Brandon Meadows, but also the panel is welcome to chime in as it sees fit. Since it has been a while, Brandon, since most lenders have dealt with this large influx of foreclosures, which we may see or we may not. I mean, I don't think anybody, as you elucidated earlier, nobody has a crystal ball on this issue. We were looking at indicators last year at this time, and 6 months past the onset of that pandemic, and it was a lot of gloom and doom, but we've got some positive economic forecasts lately, so hopefully a lot of this becomes moot. Nonetheless, good to gear up and understand where things have developed since, but it's been a while since we've dealt with huge volumes of these foreclosures, and or really the tricky predicaments that complex credits can present. So let's walk through kind of some scenarios to refresh some best practices and dealing with these odd problems that may arise. Brandon, we've seen some creative and ambitious defenses from borrowers over the past decade plus. And these defenses have cost lenders a lot of time, a lot of money, which is certainly insult to injury on a bad credit. What are some common defenses that loss mitigation, special assets departments should be aware of? And what can the lender and the law firm do to mitigate these defenses?
Thank you, Charlie. Yeah, as far as creative, yeah, I've seen them all. That doesn't necessarily mean they have merit, but if I were to, there are certain defenses that are factual in nature, and so those typically are the ones that really can gum up your case, keep you from getting entry of a summary judgment. Things that I would just say from a best practices standpoint, we need to control what we can control, right? And so if I were, some of the top, defenses that we always see, whether it's an affirmative defense or, repurposed as some form of a affirmative relief, is the failure to follow conditions precedent, right? So that's an easy one that we can control. So, read the loan documents. It's important that we follow those conditions precedent to a T. So you need to properly notice the default, understand who to send it to, understand how many days that you have before you can properly accelerate the loan, understand whether it needs to be by certified mail and what address it needs to go to, and understand how many days you have to give them an opportunity to cure before you can file suit. Nightmare scenarios that I've seen even recently would be cases where lender takes a very aggressive approach and accelerates before giving the required opportunity to cure, or otherwise doesn't strictly comply with those notice provisions. I mean, if you want to give a debtor an opportunity to gum up your case, don't read your loan documents, right? And so we're not going to let you do that. So that's conditions proceeding is number one, because it has to do more with procedure rather than are they paying their debts. Okay, so that's a big one. So my thing to you all would be, the saying of, an ounce of prevention is worth a pound of cure, right? So take the time, know the loan documents, understand the notice and conditions proceeding before accelerating and filing suit. Other big defenses that are really factual in nature would be
update your loan documents based on lessons learned. You'd be Absolutely. So shocked at how many times that never gets resolved. And we just do the same thing over and over and over again. Absolutely.
That's on the back end to see poorly drafted loan documents. That's always the next follow up is let's not relive this nightmare again. So other defenses that I see that are factual in nature are, waiver, estoppel, or modification by conduct. And so, when you're dealing with a delinquent borrower or a workout, or you're negotiating, a forbearance, and you're doing really any servicing actions, there's always that you're now getting you're getting off the track, right? And so there's communications that are not regular or computer generated. And so we're kind of in this, off of the regular servicing track. And now there's all these opportunities to communicate with the borrowers via email, via phone. And what you'll always hear is, well, the lender told me X, or the lender accepted partial payment, the lender accepted late payments, and therefore they can't require me to make payments on time in the future. And even if you have anti-waiver provisions in the loan documents, so like to Charlie's point, you could have a really tight loan document. The law says you can still modify your contract by conduct. And so how do we control that? We just need to be careful and be disciplined that when we're communicating to borrowers, when we're accepting the out of the norm, out of the ordinary, we need to just button that up with, okay, we're going to accept this, but just be aware that we're reserving and preserving all of our rights. This shall not be deemed a waiver or modification, etc. And so there's very easy things that we can do, and we can sort of help you do that if we're in there early enough when you have problem credits that you're trying to work out, on a forbearance or pre-litigation to just try to help make sure that we're preserving our rights and knowing that these defenses are coming. And ultimately, the courts are going to look at those on summary judgment, and it's not going to take a lot. I mean, we'll see under the new summary judgment standard, but it's not going to take a lot for the defendant to file an affidavit saying, well, they told me X, Y, and Z, I relied upon that, and therefore I'm not technically in default. So let's not get ourselves in that situation, because those are really sort of things that we can control with just a little bit of prevention.
If we were playing special asset officer Family Feud, waiver, estoppel, modification by conduct would come up very high on the yes. Big board of things that they're afraid of and concerned with, based on my experience. But if done right, your point is, if done right, you're not going to have that type of waiver, estoppel, modification. And the reality is, that's a very fact-intensive matter that very well could protract the foreclosure process, but it's a very defeatable defense.
Yes,
it just gums it up. Mr. Calhoun, we've got a dead borrower. We've got someone in bankruptcy. What are the real high levels? What do we got? What do we have to be concerned with, real quick, on a common scenario like that always raises a what's the immediate steps that we got to take question?
Sure, yeah, and I like how you said real quick, because both of these issues could be a presentation of their own. Lot to it, but with the deceased borrower, on the pre-foreclosure side, there are recent Reg X rules that apply to successor in interests. identifying those, confirming those, and then treating them as the borrower. So just need to be aware of those rules. When we start rolling into the foreclosure phase for the deceased borrowers, there are options. Has a probate been opened by the heirs? If not, do you want to try contacting heirs and have a voluntary, amicable, cooperative probate with the heirs, between lender and heirs? If probate doesn't look like the right option, then who are you going to sue? You should do your own due diligence on identifying who heirs could be. And then when you identify some heirs, you include them as defendants. And then you also include unknown heirs. And then we suggest you move to have an attorney ad litem appointed to represent the unknown heirs and close the loop and help ensure you've got all the proper parties included. Switching over to bankruptcy, first step, as soon as you hear about the bankruptcy, put a hold in place, a bankruptcy hold. I've seen it too many times where, in the bank, one hand's not talking to the other, and the bank's still sending out collection letters to the borrower in bankruptcy, and that's a no-no. That could violate the automatic stay. Another mistake that I've seen made by some lenders is they put their head in the sand, ignore or stand back and not participate in the bankruptcy, and think that's penny wise, pound foolish. A lender is a secured creditor with a lot of rights in a bankruptcy case and should actively participate in the case to assert those rights and preserve its full collateral value and maximize its recovery. And then last, does it make sense to move for stay relief? It doesn't always. Sometimes it's better to live within the bankruptcy case and get paid out of the bankruptcy case versus moving for automatic stay to get out of the case and go over into state law foreclosure.
One last question before we pivot to Hunter Faulkner, who hasn't had a chance to chime in from the kind of the transactional perspective. But Brandon, we've had a good 5+ year run of lending to support investment that relies on tenant occupancy. With this renters market, that means lenders will likely have to, and we're seeing that they're having to confront a lot of tenant evictions that will come with foreclosures. Can you walk us through just a couple of common scenarios and advise on best practices in addressing those scenarios with respect to tenant evictions?
Sure. Yes. So having a tenant in there, you obviously there's a property interest or a possessory right, and so that just adds another wrinkle to the foreclosure action. I think big takeaways are that that there is law in Florida and there's federal law that has been passed that sort of protect the rights of tenants after foreclosure. There was the Protecting Tenants After Foreclosure Act, which was signed into law by President Obama, and then there was a version of that which codified it in Florida, and then later President Trump revived the President Obama's Protecting Tenants After Foreclosure Act. And so I won't get into all the minutiae of that, but what I will just say is that it's important that you know that the tenants have rights after foreclosure. There is I believe it's a 90-day notice of vacation. Notice of, basically for them to be evicted, and you got to follow those to a T. You got to give the tenants an opportunity to get out. And then just from a best practices standpoint, you should know this well in advance. If you're foreclosing, you need to understand who, from a service to process standpoint, are there tenants in the property that are staying in possession? Secondarily, you're going to need to take some discovery. When you're doing discovery, you need to take discovery on the lease, because some of the factors in getting there's exceptions in the tenant in that act, specifically like if the tenant's a former owner, or the lease is less than fair market value, or it's not an arm's length transaction, or if there's no lease at all. Those are exceptions. So it's important to kind of be proactive, stay ahead of that, take discovery on that issue, and be prepared immediately after foreclosure so you can kickstart that writ of possession so you can take control of the asset.
Thank you. We've just really glossed over some big topics that could be subject to follow-up webinars in which we may consider, but those are high level on some really important issues. Let me pivot to Hunter Faulkner. Thank you for your patience, Hunter. So what are, from your perspective, who often handles REO dispositions, what are the best practices for avoiding last-minute title issues on a foreclosure to ensure a smooth foreclosure sale and then subsequently a clean disposition of the asset?
Thank you, Charlie. Well, there's, what we employ here and what I employ in my practice is a routine update of the title history of the property from the date of the final judgment of foreclosure through the foreclosure sale. It seems like an easy step, but it's honestly surprising how many times title is neglected to be updated throughout this process. Also, best practices, for me, is to advise the lender regularly with these updates, no matter if a claim is present, a new claim, is present on title or not. So that way the lender can keep track of whether when title is updated and whether or not any new claims show up. Last, it allows lenders counsel to be proactive in the event of a new claim. For an example, if there's a new municipal lien or utilities lien or HOA lien that appears on title, that way now we have time to properly assess the validity of this claim and whether or not it will affect title or whether or not it can be removed. So we look back to the foreclosure proceedings to make sure these parties were noticed, so on and so forth. Another step to mitigate any potential hiccups is be aware of your deadlines. Following the final judgment of foreclosure, the foreclosure auction is going to be scheduled within 20 to 35 days following that final judgment. It will only be extended in the event that the court grants an extension. Following the sale, the issuance of a certificate of sale, as I'm sure most everybody attending here today knows, the defendants will have that 10-day right to object to the sale, to satisfy the final judgment of foreclosure, and to redeem the property. Otherwise, after 10 days, a certificate of title is issued to the party that prevailed at the foreclosure auction. So these are some high-level things to not only be aware of, but to actively pursue a diligent title search and updates so that you stay aware of any issues and stay in front of them as you move forward prior to the foreclosure.
And Hunter, what are some big ticket items that SAT officers need to be aware of when preparing to carry, maintain, or resell an REO property after it's been acquired at foreclosure sale?
Right. So assuming that the property was redeemed by the lender without issue, lenders need to be aware of big ticket items that affect the property, and it depends on how long the lender expects to carry the asset. So a good example of this, and you will know this within the final judgment of foreclosure, is whether or not a notice of a federal tax lien was filed on the property by the IRS. So if a federal tax lien was filed, then the IRS has an automatic 120-day right of redemption on that property from the date of foreclosure. So if, like in most cases, conventional lenders don't want to carry assets for too long in their books, they'd like to unload them to a bona fide third-party purchaser. However, a 120-day right of redemption on a property, title will not be marketable until that 120-day period has elapsed. Similarly, if there's a U.S. government judgment, other than a notice of federal tax lien on the property, you're going to have a 1-year right of redemption for the U.S. government to come back and redeem that property. So these are high-level issues and examples of things that could affect the disposition of the property once it becomes REO. Another very important thing to know as far as the title insurance side of this is concerned is that all title insurers are going to conduct a diligent underwriting of the foreclosure process from the initial list pendants all the way to the final judgment of foreclosure. They're just going to go back and double check everything that was done to make sure that there are no hiccups along the way. They're going to be, reviewing the legal description. So we're going to make sure that all of our filings throughout the foreclosure process, the legal description is accurate and it matches throughout the process. But they're going to be backing that up as well. And there's several other items that they check. But there are specific things that they do not check, that they rely on the title agent who's handling the closing of the REO property to verify and satisfy the requirements. So one is that the property is unoccupied. Another is that the the proposed insured sale is not to a related party to the foreclosing mortgagee, and that there's no other ongoing litigation, no other actual knowledge, of ongoing litigation surrounding the mortgage. These requirements are going to, again, be relying upon the title agent handling the closing to take care of these. So my point is, if for any reason the REO closing is being dealt with by a third-party title company or somebody who's inexperienced in handling these matters, it's going to likely cause delays and hiccups along the way. So what do we want to emphasize? A smooth, successful closing. When you have an experienced attorney with closing REO properties, you'll have the proper affidavits and forms prepared for signature in advance of closing so that there are no hiccups and the property can be conveyed legally with marketable title.
Great job. Thank you. It is 11 now. Austin Hamilton, if you could just give us a real short flyover on you foreclosed the property. Now what? Walk us through real quickly on the deficiency process and whether those extra steps are worth it. And then we will hang around for 10 minutes for Q&A if anybody has any supplemental ones. I understand people only blocked an hour on the calendar, so if you need to fall off, that's okay too. We will be following up with materials, both relative to this presentation and a couple of our blog posting series that really do a little bit deeper dives on these topics and others that are relative to loan liquidations and foreclosures and things of that nature. So, Mr. Hamilton?
Sure, thank you, Charlie. And I think the easiest way to expedite this would be to put up the slide I anticipated that we may, with all the content that we have, we may run out of time. So to hit the Cliff Notes version, when you're seeking a deficiency judgment, one, it's an effective way to minimize losses, but it should be evaluated on a case-by-case basis and hopefully can look into and determine whether the defendant would have any other assets from which a judgment could, or the lender could collect. There's two ways to obtain the deficiency judgment, either a motion for deficiency judgment in the existing foreclosure action or a separate lawsuit to collect or to seek the deficiency unless the court in the foreclosure action has already granted or denied a claim for deficiency judgment. One thing to always remember is there is a 1-year statute of limitations. That 1 year runs from the day after the certificate of sale is issued by the clerk or the day after the mortgagee accepts a deed in lieu of foreclosure. And then with regard to determining the amount of the deficiency, it's the difference between the judgment amount and the fair market value of the property on the date of the foreclosure sale. The actual for sale price itself is irrelevant to that analysis. And the burden of proof is going to be on the party moving for the deficiency judgment. It's going to require an appraisal as of the date of the foreclosure sale, and oftentimes judges will require live testimony to establish the amount of that appraisal and the amount of the deficiency judgment.
Yeah, that last point, as we were talking yesterday, sharing war stories.
Yeah.
I had a really early experience in my legal career where we had an uncontested foreclosure, showed up for a deficiency proceeding, and the judge, thankfully we had the appraiser lined up, but the judge spent an hour himself cross-examining my appraiser witness and in a completely uncontested proceeding. And thankfully our guy was prepared and we got everything we asked for, every penny. But you have to be prepared for the unexpected sometimes when it comes to evidentiary-based deficiency proceedings. With that said, Nikos, I don't know if you're still on and you're able to chime in about how to contact our panelists or any follow-up that we might have on behalf of the firm. Like I said, we will be sticking around for another 10 minutes or so. If anybody has questions, you can submit them either through typing it out through the Teams portal, or Nikos, I'm not sure if they're able to just chime in and fire away.
Yeah, they can. If anybody wants to submit a question at this point, in case you missed the initial instructions, we can put the slide up that gives you those instructions there. Submit them by clicking on the little Q&A bubble. It has a question mark in it. You'll find it somewhere on your screen, usually in the upper right-hand corner. And then just type in your question and submit it. Even if we're not able to get to it in the time that we have here, it's possible that we could do some follow-up once the presentation has concluded. But otherwise, while we wait on some questions to come in, we definitely appreciate everybody joining us today, tuning into this panel discussion. Appreciate all of the panelists, Austin Calhoun, Brandon Meadows, Austin Hamilton, Hunter Faulkner, and the moderator, Charles Jimerson. We're going to follow up with some contact information for all of them that you can be in touch with them directly, even download some B cards if you wanted to make a personal follow-up. And please feel free as well to visit the firm's website for more information. You could actually go to jimersonfirm.com, click on the banking and financial services industry tab, and there's a wealth of information and resources there and content that the presenters and panelists today have produced on these topics that takes a much deeper look at almost every one of the topics that we've covered today. And you can always call us for more information as well at 904-389-0050. And seeing no additional questions coming through at this point, if you got any feedback for us on the presentation, feel free to send that to us via the link you'll receive as a follow-up in your email. You'll get a quick survey. Hope you'll take the time to fill that out to help us figure out what other topics you may be interested in hearing about in the future. Charlie, I'll kick it back over to you if you want to take some of the questions that were submitted beforehand. There's still about 16 people with us at this point, so leave that up to you and your timing.
Sure. Yeah, I just wanted to add on your remarks there, Nikos. To the extent that any of your departments or any of the special assets officers that have joined us have ongoing training needs or some particular topic where you want to learn more about the law, whether it's Florida-based or a national issue or even an operations issue, please submit that to us. We'd be happy to conduct a private webinar or even an in-person training session if necessary. But we are scholars of this industry. We're constantly studying the law. We get a fair amount of at-bats through our work with a wide array of clients. But we want to share that knowledge with you, and certainly at no cost. We believe in the Japanese art of Kaizen, which is a lifelong commitment to constant improvement. So we're always learning and growing, and as we learn and grow, we want our clients to learn and grow with us.
Well, thanks everybody for joining us. We certainly appreciate your attendance and your interest in the topic. We wish you a good rest of the day and a great rest of your week.